I don't want to sit here and refill all my
It
strength.
sounds unreal that Tinubu will threaten the tribunal judges to deliver justice in his favor, or else there will be anarchy. Did he really say this? The story was reported by many Nigerian newspapers. Let's look at the source of the news. It came from the final address of Tinubu's legal team to the Presidential Election Petition Tribunal. After they made their argument on why 25% is not required in Abuja, by the way, they ended up accepting that 25% is mandatory in Abuja. But we'll come back to that in a moment. They concluded by saying, with much respect, any other interpretation different from this will lead to absurdity, chaos, anarchy, and alteration of the very intention of the legislator. Our courts have always adopted the purposeful approach to the interpretation of our constitution. This is a new law and it shows how desperate they've become. What message are they sending to the international community? That they will not obey the order of the court when he is eventually sacked? And they expect foreign investors to come to a country where their leaders don't obey the laws? This sounds so much like what a thug will say. Have lawyers become thugs? Or are they just passing the message like their client wanted them to? This is a direct threat to the tribunal judges, and no, nothing will happen. There will be no anarchy if Tinubu is removed from office. Instead, there will be wild jubilations across the country. Millions will troop out to dance and celebrate. Tinubu's declaration was the only time in Nigeria's recent history that people didn't troop out to celebrate. So who will cause the chaos when it's an open secret that he didn't win the election? This is the only election in recent history that Nigerians are sure that the announced winner didn't win the election. In 2015, it was obvious that Buhari won the election, although many underage voters voted for him in the north. Also in 2019. But you see this 2023 presidential election, Tinubu didn't win. That's why the court will sack him and nothing will happen. Some of his supporters are already regretting ever working for him. It won't be a surprise if they join others in celebrating his sack. This is because in just a few weeks, he caused more hardship than Buhari will ever dream of. Not that subsidy removal or reduction shouldn't happen, but you can't triple the cost of fuel and expect workers and business owners not to suffer. Petrol is the live wire of Nigeria's economy. Even in Western countries, if the price of petrol triples without warning, it will seriously cripple their economy. And to add insult to injury, look at this. What a waste. 40 billion naira just for luxury SUVs for the National Assembly members, when Nigerians are resigning from their jobs because their salaries can no longer pay their transport fares. Transport fares have tripled since the price of petrol went up. These workers have dependents that they take care of. Some of them are living in the cities, some are living in the rural areas. So imagine the effect of the sudden increase in price of fuel on Nigerians. Why do Nigerian politicians specialize in spending money on frivolities, but they can never create wealth in the first place? They said they will spend billions of naira on palliatives, that they will share 8,000 naira each to 12 million people. What effect will that have on the economy? Or is this another scheme? More than 50% of this money will never get to the real people. They will never account for the money. Instead of wasting billions, why not use the money to buy thousands of dual fuel buses to ease the transportation costs for workers? That will have more effect on the economy. Compressed natural gas is very cheap, about 150 naira per kg. If these buses run on CNG, it will drastically reduce transportation costs, and the buses are manufactured in Nigeria, so it will create more jobs for Nigerians. Increase in salaries should be directed to people that need it most. All military personnel, police, all security agencies, they need to increase their salaries instead of dumping more money on National Assembly members who earn millions of naira already. This is very simple. Why is it so hard for politicians to understand? Coming back to the own goal they scored after arguing against 25% requirement in Abuja, they concluded that the word "and" is conjunctive, which is in agreement with the Supreme Court ruling in 2008. Is it that they don't understand the meaning? Because if they agree that it is conjunctive, that means whatever applies to the states must apply to the FCT. That's logical conjunction. We didn't really expect that after arguing against something that they will end up agreeing with it. That's why we didn't spend much time reading the entire 42 pages of their final address. Maybe their lawyers truly believe that it is the correct interpretation, because out of the abundance of the heart, the mouth speaketh. But you know, lawyers will always defend their client. In order to understand why they've become desperate to the level of threatening the tribunal judges, let's appraise their performance so far in court, including their final address. How did they counter all the reliefs sought by the petitioners? Starting with the election itself, the petitioners said that the way INEC conducted the presidential election was in gross violation of the Electoral Act and their own guidelines and regulations. To support this claim, the petitioners tendered various INEC certified true copies of result sheets, running into thousands. Although INEC didn't deliver all documents they requested, they still brought a substantial number to prove their case. And because INEC gave reasons why the upload of presidential election result sheets didn't work on election day, they tendered evidence from Amazon Web Services, which hosts IREF. The evidence proved that there was no glitch as INEC claimed. And if there was no glitch, it proves that it was an INEC web administrator that blocked or changed polling officers' passwords and generally prevented upload of presidential election result sheets. Labour Party supported all these documents by calling 13 witnesses. On PDP's side, they called more than 20 witnesses. Now, how did the defendants counter the evidence submitted by the petitioners? What type of documents did they tender in court to try and convince the judges otherwise? The defendants tendered only one document to support their claim that they deployed patches to mitigate the glitch. They claimed they had the right to collate the results any way they wanted. They cited one court judgment that reinforced that right. So they didn't address the issues raised by the petitioners. They didn't in any way tender documents to try to prove that the manual collation they decided to use for only presidential election was correctly done. That despite not following the law by uploading the results at the polling units, that they made sure that the results reflected what voters voted at the polling unit. They didn't prove any of this. This is the main issue that the petitioners proved, but they didn't counter it. They are banking on the fact that he who alleges should prove. But they forgot that if someone makes an allegation against you and tenders evidence to prove the allegation, you have to counter that person to stand a chance. Why will the judges just believe them when the figures in front of them say otherwise? They can't just tell the court that despite not uploading the result sheets at the polling units, that it didn't affect the results at the end of the day. But the evidence says otherwise. The few states the Labour Party released their results, the results are quite different from what INEC announced. So if you are a judge in this case, how will you judge them? Next is the disqualification of Tinubu. The petitioners tendered lots of evidence to prove their case that Tinubu's forfeiture of $460,000 to the US authorities was criminal in nature because the money in question are proceeds of narcotics trafficking. They stated that it violated Nigerian laws to allow such a person that was once involved in narcotics to become the president. So what did the defendants bring to court to counter these and prove to the court that they should not disqualify Tinubu? They tendered a letter from the US Embassy. They hoped to convince the judges that before this letter was written, the FBI and other security agencies in the US conducted a search and came up that Tinubu didn't commit any crime in the US. They are also arguing that the forfeiture was civil in nature, not that it didn't happen, that Tinubu should not be held responsible for the money in his account. In other words, what they are saying is that despite Tinubu forfeiting narcotics money, that he shouldn't be disqualified. How will you decide if you are the judge in this case? It's not hard to decide. Look at this analogy. Some guy stole a car and goes on to sell the car. After collecting the money, they deposit the money in a bank account of an accomplice. Whether all of them stole the car together or not is irrelevant here, because if anyone is in possession of stolen property, the person is already in violation of the law. Mind you, in this particular case, the police have already arrested the people who stole the car. In fact, some of them have already been convicted, and the police, while making further investigations, discovered the money in the account. They search for the owner, but the person has taken flight. They eventually get the person's phone number and put a call across. During the first call, the person accepted everything, including knowing the people already in prison. By the time they called him the second time, he recanted his earlier statements. He must have discovered that his earlier statement put him in serious problem. The authorities eventually decide not to pursue him and just recover the money. So you be the judge. There's also the issue of certificate forgery. The petitioners tendered evidence they got from INEC. They also tendered the ones they got from Chicago State University. The defendants didn't address the issue of forgery at all. They ignored it completely. They only tendered school records from Chicago State University, which doesn't address the issue of forgery in any way. So on what legal basis are they arguing? If you're the judge, how will you decide this? Another plea by the petitioners is Shetima's double nomination. They want Tinubu disqualified because of that. The petitioners tendered evidence to support their case, and the defendants tendered a Supreme Court judgment. This one is looking like the only one they made a good effort. But if you're a judge in this case, tell us in the comments how you will decide. For context, the petitioners are saying that starting from the first time that Tinubu announced Shetima's nomination, he held the two nominations for some time before writing his party informing them of his withdrawal from the senatorial race. Next is 25% requirement in Abuja. They also supported their case by tendering a Supreme Court judgment on the matter. They want the judges to interpret Section 134 of 1999 Constitution. On the other hand, the defendants are telling the judges that Abuja is a state. They cited Section 299 of the Constitution, despite Abuja not listed among the states in the Constitution. In closing, they threatened the judges not to ever contemplate sacking Tinubu based on 25% requirement in Abuja, that if they do that, of course you know the rest. So you can see why they've become desperate. They can't defend anything. They thought it will be like other elections. The petitioners will go and waste their time in court and be told by the court that they couldn't prove their case. This time it is different, and the evidence is so overwhelming, and absolutely nothing will happen when Tinubu is sacked. Thanks for watching.